Good morning. The appellate court for the state of Connecticut is now open and in session. For the record, we are conducting this hearing virtually via Teams and are live streaming this hearing on YouTube. Counsel are advised that to the extent that there is statutorily protected parties and or information here, that you take extra care to not reveal said protected information. I would ask that everyone participating in the hearing identify themselves, starting with the judges, then counsel for the appellant, and finally counsel for the appellee. I am Judge Elgo.
I am Judge Cradle.
Good morning, Judge Clark.
Attorney Keith Yagaloff for the defendant appellant.
Robert O'Brien of Shipman and Goodwin for the Appalachee Regional School District number 8.
Thank you. For the record, I note that I can hear and see everyone. Please let us know if in the course of your argument you're experiencing any difficulties hearing or seeing the participants. If you should lose your audio or video capability, please log out and retry the Teams link you were sent for this hearing. In that event, we will pause the proceedings. All participants must keep their video on and remain in view out of respect for the process and the participants. All participants are also asked to keep your microphones off and muted when you are not speaking. The judges will raise their hand if they have a question and to avoid talking over whoever is speaking, but will interrupt if you, for some reason, do not see them. Please keep in mind that while this is a virtual hearing, all participants are expected to conduct themselves with the same formality and respect for the process as you would in our courtroom. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal and should advise me before you begin how much, if any, time is requested for rebuttal. Judge Cradle has kindly agreed to be our timekeeper and will give you a 2-minute warning and when your time is up. So this is now the matter of Regional District 8 and M&S Paving, docket number 43549, and the appellant may proceed. Attorney Yagaloff.
Thank you, Your Honor. Good morning, judges. May it please the court, I represent M&S Paving. I'd like to reserve 5 minutes, please.
All right, you've got that. All right, go ahead.
And this is a case, as you know, that involves the replacement of stairs at a school. And my clients, M&S Paving, were contracted to replace the stairs, to actually replace them, to do a replacement of the existing stairs, and to reuse the railings on those stairs. They did that work completed it before the start of the school year, for the year that the work was completed. And they had no issues with these stairs in any respect until January, 5 months later, in the middle of the winter during a snowstorm, when it was reported that there was fracturing of one of the stairs on the stairs, concrete stairs itself. I want to emphasize that there was no evidence of any defects, any evidence of any cracking, evidence of any complaints about the stairs prior to the observation that the stairs were fractured on that particular date. They had paid the plaintiff had paid plaintiff had paid the contract fee and had inspected the stairs and prior to paying the fee, and had not found any issues at all whatsoever with the stairs. We had a trial. There was no expert testimony as to causation. There was no expert offered, and no testimony as to the materials or workmanship. There was no testimony as to the cause for the fracturing of the stairs. There was no expert testimony whatsoever that was either offered or accepted by the court as to the underlying work on the concrete stairs. There was testimony from a building code official that testified about building code violations. One of the claims that was made by the district was that the stairs were constructed in violation of the building codes. I'm going to read from the judge's decision in a second and tell you how the judge found this, because I think it's important to emphasize this. However, I just want to explain what happened with these stairs in case you're unable to discern it from the pleadings. when you have stairs that have at the bottom of the stairs an uneven surface, like a sloped stairway, sloped sidewalk, or at the top of the stairs where there's a sloped sidewalk, the code permits variations in the height of the stairs at those areas. So that if it's a significant slope at the bottom of the stairs, there's going to be changes in the height of the riser at the bottom of those stairs because naturally because of the sloping surface that the stairway meets at the bottom and top of the stairs. The trial court judge found that that the defendant proved that it had complied substantially with the terms of the contract. I'm looking at the memorandum decision at page 5, which is plaintiff's exhibit appendix exhibit number page 17. The court noted that some of the steps slightly exceeded the code standards for tread depth and riser height. And it also noted that the defendant was to reuse the existing railings. The court noted that the plaintiff suffered no diminution in benefit of the bargain because of the minor deviations that were described, and that the school system enjoyed full use of the stairs until the cracking nearly 5 months later. And it said that the court found that the defendant proved its fourth special defense, which was acquiescence or ratification with respect to the violations. And it also found, I believe, as to the second special defense as well. It said the court said that the plaintiff cannot prevail on a breach of contract claim based on the code violations. That's the bottom line. That these were minor violations that were. Yes, Your Honor.
Well, counsel, I understand that you prevailed on those issues, but obviously the issue that's on appeal is the court's finding of the breach of the defective workmanship, correct?
It is,
So,
Your Honor, but
and
yes.
I understand that I understand that your claim is that there's no expert testimony regarding the causation piece of it.
Yes.
But it does appear to be the kind of defect that not only is obvious, but one that you wouldn't expect in work that has been done and that's only 4 or 5 months old, correct? And that these materials that crack just continued to get worse, it sounds like, correct?
No, Your Honor, I don't agree with that last part of it. And
Okay.
and you actually you had 3 things there that I'm listening to that I wanted to address. One was why I'm talking about the building code violations. One is the obvious what you're saying could be considered an obvious defect. Stairs don't crack on their own. And then the third one was whether there was continuing cracking or that these continue to deteriorate. Let me try to say first, let me tell you why I talked about the building code violations, because the judge awarded damages in part because the stairs needed to be replaced on account of what the judge says was the building code violations. And the problem with that is that when the judge awarded damages, it didn't, the defendant didn't, the plaintiff did not put into evidence any of the cost or expected cost to repair any of the cracks in the stairs. And His Honor actually said in the trial case that he awarded the damages because the stairs needed to be replaced in part because of the building code violations. So the problem we have was that the trial judge says, well, we're not going to hold you responsible for building code violations, but we are going to give the plaintiff the full cost of demolishing and replacing the stairs in part because of the building code violations. And that was the reason I was emphasizing the fact that the court did not find for the plaintiff as to the building code violations, but did award damages as a result of those violations. So the second issue, Your Honor, is whether, let me go to the third issue first. Yes, Your Honor.
So, okay, but I mean, if we assume that the plaintiff, proved its case with respect to defective workmanship and therefore there was a breach, I guess I'm struggling to understand it. So now everyone's aware of the code violations. How would the court go about determining, the damages? What should the plaintiff have done? Reconstructed stairs that, according to the initial specs wouldn't have complied with the code violations, or somehow determined the difference in the cost of constructing stairs that did or did not comply with the code violations? I'm just trying to understand once the plaintiff gets that knowledge, and if we assume he's entitled to, the district is entitled to replace the stairs by virtue of the breach, what's your argument with respect to damages now?
Yeah, so that's a good point, Your Honor. However, I believe the testimony was that the building code violations were de minimis and they were arising as a result of the slope stairs, which the code created exceptions for those violations. And there was a lot of testimony about that. So these were not violations that would have required any kind of replacements because they were permissible. And
no, I get that. But if we assume that they were entitled to replace the stairs because of the defects at issue, your argument is, I guess, I'm trying to understand what your argument is. I mean, they went ahead and replaced the stairs that did comply with the code violations, and I guess you're saying that cost more than if they hadn't, and therefore they're getting more than what they had bargained for under the initial contract, and the damages weren't computed properly. But then the question becomes, what are the proper damages at that point, in your view?
Yes, so Your Honor, I would say that the proper damages would be first to assess, could the repairs have been made to the cracked stairs? And if those repairs, if there was a cost that could have been, if there was a cost attributable to just the repair of the cracking, then that would have been the damages. The replacement stairs were not necessary, but for, and Your Honor, I believe it was not just but for the cracking. The testimony was that the replacement stairs were done but for the code violations as well as the cracking. Could I just, maybe I could jump to the third part, Your Honor? I'm sorry.
Well, I guess it seems to me that if the new contractor has to replace the cracking, right, that needs to happen, correct? But
no, Your Honor, I disagree, Your Honor, because there was evidence that the cracking could have been repaired. The cracking could be repaired, not replaced. There's a method. There was a method apparently from the other contractor that came in that testified that he in fact had made repairs to cracking that occurred on his stairs.
But then now if the new contractor has to replace and let's say that they can just fix the cracking.
Right.
Wouldn't it still warrant their having to, they can't do that without having a problem with the code violations, which were part and parcel of what even though there wasn't necessarily a breach with respect to the code violations because they had accepted it and there was substantial performance deemed, now we have a new contractor that has to redo everything.
Your Honor, I would say that there was no evidence that the code violations required any changes to the stairs, that there was not testimony that those violations required that there be replacement or changes to the stairs, that those were de minimis height and riser changes that were attributable to the sloping of the bottom and top of the sidewalks. And I don't believe there was any testimony from any person, including especially the town inspector, for example, that said that those stairs needed to be replaced as a result of the code violations. They were acceptable. They were acceptable. They had been there before. The inspector didn't say that anything needed to be replaced, and there was no expert said that they needed to be replaced or that they affected safety or that they affected the function of the stairs. At the bottom and the top of the stairs where there's sloping sidewalks, there are going to be changes in the run and rise, and that was permissible. And I think that the court never got into that issue, Your Honor, as to whether or not the stairs needed to be replaced as a result of the code violations. If I could just come back to this cracking, the cracking that occurred subsequent to the fracturing was not, there was no testimony that was other than anything that was normal types of, it was apparently fine cracking that occurred. Their expert that did the replacement said that they saw the same cracking that was caused by, he believed, salt, that he had told the school district to stop applying to the concrete. Yes, Your Honor.
What evidence was introduced to support your client's contention that a snowplow hit that railing?
There was evidence that the railing handle had been fractured and required welding at around the time of the fracturing of the concrete. Yes, Your Honor.
Well, what you keep saying that. What was the evidence?
Their evidence was that there was a call that was made to the welder to have him go out there, and there was a note on one of the orders or one of the documents that said the welder had welded. Yes, Your Honor.
A call from whom to the welder?
Believe that the log was I can't recall, Your Honor, if it was a notation that was on a document from the school district indicating that the welder had gone out, or whether it was an M&S document indicating that the welder had gone out and welded. I don't think it was disputed, Your Honor, that the welder had welded the stairs,
No,
the railing. Yes,
but
Your
it
Honor.
was disputed that the welder should have been there. I mean, the plaintiff's position is they didn't ask for a welder to come out, and
Yes, Your Honor.
that M&S did that on its own, and they had no idea why. And we're just, I mean, this is the key piece of evidence for you, it seems to me, because if you can't prove that there was some other cause unattributable to your client's work, you're in big trouble, I think, and that's certainly what the trial court found. So I'm just trying to understand what evidence you're relying upon for this very key issue.
So, Your Honor, let me go back to the central issue and answer that. I have 2 minutes left. I want to explain the central issue. I thought that the burden of proof was on the plaintiff to prove causation. And I thought going into this that they would have to have an expert witness testify that there was a defect in the material or workmanship in order to prove causation. So we were there at trial expecting that the plaintiff would have to put on some evidence, expert testimony, that the material or the workmanship was done improperly. In fact, and you're asking me, Your Honor, in a sense, to say, you know, the burden. You're not saying the burden of proof is on the defendant, but we went into this expecting that the plaintiff would have to prove their case. I don't agree, Your Honor, Judge Elgo, when you said earlier, you know, 5 months is based on the cases that I've cited in the case law in Connecticut. I think 5 months is outside the realm of something that happens without any evidence prior to that at all. Absolutely no evidence of any kind of defects. All of a sudden, in 5 months, something appears, a fracturing. It's not fine cracking. It's a fracturing of the concrete step. And I think that takes this case outside of the realm of other cases that have looked at inherent defects or defects that you can infer were caused by workmanship. All the other cases that I cited to, and I believe Connecticut law stands for the proposition that there should be some indicia of a defect at or around the time of the installation of the product, and that there should be some continuing changes in the nature of that. Yes, Your Honor.
So your position is if the defect is latent, there is a per se rule that expert testimony will be required.
No, Your Honor, I'm not saying that at all, and I understand your point there. However, there's no evidence that this was a latent defect, Your Honor.
All right. Thank you very much. We'll hear from you on rebuttal. And Attorney O'Brien.
Thank you, and good morning, Your Honors. May it please the court. While the issues are fresh in our mind, there are a couple things I'd like to address right off the bat, and that is, Judge Clark, you alluded to this what we call the snowplow theory in this case, and I want to be absolutely perfectly clear. There was no evidence presented with respect to any kind of snowplow or anything else hitting the stairs or hitting the railing. We and the judge rejected that. We made a reference to it on page 3 of our brief in a footnote, and we indicate that there was a complete lack of evidence, and the trial court correctly rejected the quote-unquote snowplow theory as mere speculation. And this is tied to another point that I wanted to make, and that is that when I think back to the trial, one of the things that was very interesting was, for whatever reason, the defendant decided not to present a witness who knew anything about the job or the problems or the attempts to repair it. There was a witness that they could have presented, and for whatever reason chose not to. So only one witness testified on behalf of M&S, and it was an officer of the company, and he, to his credit, admitted at the trial that he had never visited the site, had nothing to do with the job. So there wasn't any evidence presented by the defendant on a number of these points that that both Judge Clark you've made and Judge Elgo you've made. I think it's worth emphasizing, as we did in our brief, that the trial court judge concluded in the MOD, and I'll just read a quote from one sentence, that serious, quote unquote, serious cracking of concrete within 6 months of formation leads the court to infer unworkmanlike performance unless the fragility of the product can be attributable to some outside force, close quote. We quoted that in our brief. It's obviously in the MOD. And in conjunction with that, in our appendix to our brief, beginning at appendix page 11 and continuing for, I think, 3 or 4 pages, 11, 12, 13, 14, we have the color photos that were introduced as evidence at the trial. If you look at those, particularly on pages 12, 13, and 14, the idea that anybody can suggest that this is somehow normal cracking or settling of concrete is frankly ridiculous. These are a huge set of stairs that run from a lower level where people park their cars outside the school up to the top where the school buses arrive, and then you walk across a sort of a roadway to enter the school. When this cracking developed, and it worsened over time, when it developed, we closed down the stairway. And you can see both before and after pictures of the stairway. The stairway was not in use for the entire spring semester of 2015. What we were hoping was to get the stairs repaired in time for the 2015 fall school reopening. We reached out to M&S on several occasions. They came out once to and performed some cosmetic repairs, which were unacceptable to the district. So the stairs remained closed for the entire school year of 2015 into 2016. Yes, Your Honor.
Counsel, I hate to interrupt, but I want to kind of get to some of the issues that I'm a little concerned with. Can you explain, I see in the court's decision that it discounted the code violations, but said it wasn't irrelevant, right? That's what the court said. Can you just help me understand how, to what extent it played in here to the court's findings and or damages?
Well, I don't think it played any role with respect to the court's decision on damages. With respect to liability, it's a little bit hard to tell, Your Honor, from the MOD, because counsel was correct that I think when we read the MOD, we probably all recognize that Judge Ferraza, who's a very experienced jurist, discounted the code violations because they were de minimis, if you will. There were code violations, but Judge Ferraza determined that they did not rise to the level of, in and of themselves, a breach of contract. But I think he took those into account in conjunction with the other evidence that he heard from the school's facility director, from the building official himself, from Mr. Racky, who was the president of the completing contractor with over 40 years of experience in the business. They all described to the judge what they saw. It's hard for me to know how the judge put all of that together, but he did, and I firmly believe he came out with the right result.
Can you also help me walk through or help us walk through his rationale on the damages here?
Well, we had paid $9,000 to M&S for M&S did other work at the school site. A portion of the work were these stairs. We paid M&S $9,000 for these stairs, and we paid them for the rest of their work. When it came time to replace the stairs, we worked through a cooperative and that the school district is a member of, and they have contractors who are on call to deal with issues like this. So Mr. Rackey's company was the on-call contractor. They prepared a detailed estimate of what they were going to do, and it came out to something like $34,000. Now, what Judge Sferrazza did, and I think he did this correctly. I'm not challenging his damages result, but what he did was he said, well, you put a new sidewalk in up at the top of the stairs, going across the top where the buses, near where the buses let out. And he said that wasn't, a new sidewalk wasn't part of the scope of M&S's original contract. And new railings were not part of the scope of the contract. So he deducted things like that. That's how he got from the 34 down to the 23. And we don't take issue with that. Now, I'm not sure whether it was Your Honor, Judge Elgo or Judge Clark who raised this, but there was no way to quantify how to fix the code violations versus replacing the entire set of stairs. We need to put this in perspective. The stairs were replaced before the lawsuit was brought. And we had to replace the stairs. We did what was necessary. We had no way of determining, okay, what would be the cost of 1/8 of an inch of a code violation? We just want new stairs. And I'm sorry to put it in such blunt and simple terms, but that's the reality of it. And at the trial, there wasn't any evidence presented by the defendant that, oh, well, you could fix the cracks and it would cost X amount of dollars. There wasn't any evidence of that. It had plenty of time to address these issues. As I mentioned earlier, we went all the way through the spring semester of 2015, the fall semester of 2016, the fall semester of 2015, and the spring semester of 2016. The work was finally done around the time that the fall school year opened in 2016, and we finally had stairs that we could use. So, is this the biggest case in the world? No, but I think that Judge Sferrazza was correct in his damages calculation, Your Honor.
I guess I appreciate that this took, a great deal of time, and in the end, from the perspective of your client, the whole thing needed to get ripped out, and started all over again. On the other hand, if the breach is the unworkmanlike performance that is based on the cracking and not on the code violations, doesn't that suggest that the whole thing doesn't need to be redone for purposes of the defendant's breach? And it's just a tough thing to wrap my head around.
Well, I think it's I think that approach, not Your Honor's approach,
yeah,
but my brother counsel's approach is a little bit of Monday morning quarterbacking. And what I mean by that is we had a letter from the building official in August of 2015. Okay, so the work had been done the year before. We closed the stairs in the spring of 15. And now we're coming up on the new school year in the fall of 2015. We had a letter from the building official, and this is before any of the repair work was done, but long before the lawsuit was brought. And the building official is telling us there are code violations. You've got a number of problems. This needs to be remedied. Okay, so even in the fall of 2015, after we got the letter, we reached out to M&S and invited them to come back. And as the transcript reflects, the individual with the most knowledge of the issue at M&S didn't show up for the meeting, and that was the last we heard of it. Yes, Your Honor.
Counselor, was there some evidence that your client provided specs that resulted in code violations and made the work cheaper than it otherwise would have been? I mean, that seems to be, what they would have to prove in order to get a lesser amount of damages, right?
That's a very good question, and it's one that I had noted earlier because Your Honor did make a reference to plans and specs. Thank you. There were no plans and specs in the original job. It was just a one-page purchase order identifying specific areas of work. So, it's that's unfortunate, but that's what we deal with. So I won't go into the appropriate standard of review because I'm quite certain that the panel is aware of those. We've addressed those in our brief. But we would respectfully request that the trial court's decision be affirmed. Thank you very much.
All right. Thank you very much.
Actually, counsel, I miscalculated the time. You actually have more time than that if you would like.
I think I'm concluded unless there's a particular question that any of the panel members would like to address.
And I apologize for that.
No problem.
All right. Hearing
Thank you.
Okay. Thank you very much, Attorney O'Brien. Attorney Yagaloff.
Thank you, Judge Elgo. I wanted to take my 5 minutes and do two things. I want to address the discussion that you just had about the building code violations and the judge's decisions. I also like to come back to Judge Clark's issue about latent defects. On the issue of building code violations, Judge Fraza at page 9 of his decision did tie that together with damages. It said the court finds it was necessary for the plaintiff to have the faulty stairs constructed by the defendant, have the stairs demolished and removed, given the cracking concrete problem, as well as the fact that the dimensions of the risers, treads, and railings violated the state building code. And Judge Clark, as to your question about providing specs, the defendant provide specs, the defendant was actually told to construct a replacement stairs for the existing stairs, and they didn't, and that's what they did. And those run and rise at the bottom and top of the stairs were exactly what had pre-existed on account of that's the nature of the lay of the land where these stairs exist. When the new contractor came out, they changed the dimensions of the stairs and the sidewalks in order to accommodate a different set of stairs. And they also had issues with the run and rise at the bottom of the slopes that were not addressed, that the building official did not inspect their stairs and say whether or not they had the same exact issues that pre-existed. Now, I just want to come back to the cases I cited as to concrete cases. The appellate court has already weighed in, as well as on the issues of cracking of concrete. I cite the Keeney, Connecticut, 93 Connecticut app at 375 and Camerata 148 Connecticut app at 751. This is at page 11 of my brief. I cite to a number of other cases that have to do with concrete, Zaranka versus Rattel, which is not an appellate court case. And the issue of latent defects, I think, is a fair one. Your Honor, if a latent defect arises at some point, at any point, we have failing concrete foundation cases that we have. If a latent defect arises, and if you have expert testimony saying that there's a latent defect, then certainly that's an issue as to the workmanship and to the materials that occurs. But for the trial court to say 5 months later, the fracturing is and I'm not putting words in trial court's mouth, Your Honor, but I'm trying to connect latent defect. If the trial court were to say there's a latent defect, because it's fracturing 5 months later in the absence of expert testimony. That's inconsistent with our other cases. And I actually could not find a case that goes out 5 months where a court inferred a workmanship or defect in materials as a result of the sudden appearance of a problem like this, especially in a concrete case. I couldn't find them. All the cases I found where the Connecticut courts, including the appellate court, have weighed in are that there are defects that are either observable at or near the time of the installation, and that though there's some deterioration as a result of that. The judge, there's no evidence of a deterioration over time in this case. In the period from August to January, there's no evidence of any cracking or deterioration or any problems with these stairs. If there was a latent defect, then you might expect that there would be some deterioration. So all of these questions are really important questions that require expert testimony to weigh in. How did the defect in the construction of the workmanship give rise to the cracking? Was it defective in materials or workmanship? I think the judge simply did an inference. Well, he didn't simply do an inference. He made an inference based solely upon the appearance of the fracturing. And then it seems that the defendant is now being asked to explain away the fracturing and to provide some other reasonable alternative. But I think the court made an error at the beginning by making that inference in the absence of expert testimony. To me, and I think, and I hope the court might agree, 5 months is just simply too long to allow for an inference to be there for technical situation like concrete. That's the argument there. I appreciate your time, Your Honors.
Thank you very much, counsel. Appreciate your arguments, and thank you for participating in this virtual hearing. We look forward to seeing you both in our regular courtroom sometime in the future. We will take this matter under advisement and recess until 10:30.
Thank you very much.
Thank you, Your Honors.
Have a good day.
Be safe.
Thank you, counselors.
Bye-bye.